You are the plaintiff?
I am the defendant.
You are the. The suit was
Dismissed.
suit dismissed.
Against which suit dismissed.
Appeal allowed.
Appeal allowed. Against which
Defendant is the.
appellant. Yeah.
That's right. Tell me what is your question of law?
That's it.
What is your question of law?
Question of law. First question of whether the first appellate court can discard the principle of law that the entries in RS Khata latest service settlement shall prevail when the same has been duly framed and
You
published
are
in the
claiming on the basis of a registered sale deed,
Yes.
right?
I am
That registered sale deed does not contain the plot number. Matter ends.
in the registered sale deed, the plot number instead of 2198 is 2192.
2192 was mentioned. So you have to, the deed has not been rectified.
The deed, but the area and the boundary is there, and boundary shall prevail. When there is an erroneous entry in the sale deed,
No, we do not.
with respect
You
to
have to get it rectified. How can this be done?
but the area of land, the nomenclature of the land,
No, whatever.
everything is there in favor of the as per the deed.
It was not your case that it has been wrongly mentioned in the deed. That was not your case. Had it been your case that it has been wrongly mentioned in the deed, the matter was different. But
Yes.
that was not your case. Now we are trying to make out a new case that it has been wrongly mentioned in the deed.
But
And
as
in
per-
fact,
as per-
the registry receipt, the document from the registry office was also called for,
Yes.
wherein it was clearly mentioned as plot number 2198, 2192, sorry.
2192,
Yes.
but the khata number, the 2192 does not comes within khata number 89.
We do not know.
It is not
That
there.
is not your
And
case. If you have not made out a case, I can understand that there can be some error. But you have to make out a case to that effect, that in the registered document there is an error. And you know how the registered documents are rectified. There is a provision for rectification of the error in the registry document. And as you said that identity is not in dispute, there is an error in the registered document. That is not your case.
That is not there.
Then
That is not there. But in fact, as per the physical position, the RS record of rights has been prepared, and out of 9 decimals, I have already sold 1 decimal to cover Sthana. And that has been deducted during the survey settlement. Total 8 decimals of land has been recorded in my name. And it is evident from the judgment of the trial court also. Internal page of the trial court judgment, Lordship, page 4.
page 4 is,
Page,
your case.
yes, para 12, it starts from. May be permitted to.
Just a moment. फर्स्ट हाफ में जो लोग थे वो लोग हैं देखने के लिए ऑर्डर बुलाइए उनको मिस्टर सुदर्शन श्रीवास्तव को
Para 12. The defendant have denied genealogical table as well as genealogy given in plain. It is further case of defendant that it is false to say that the land under khata number 89, area 1.02 decimal, having several plots.
पैरा 12 किसका पैरा 12
ये trial court first. Trial court. Running internal page 3 of the judgment. इसमें एकदम क्लैरिफाई करके स्पेसिफिक करके The defendant have denied genealogical table as well as genealogy given in plain. It is further case of defendant that it is false to say that the land under khata number 89, area 1.02 decimal, having several plots, including plot number 2198, area 0.09 acres, in joint family property, rather all recorded rayat during their lifetime partitioned the property recorded in their name orally and according to village custom, Bakuda Batwara, and the aforesaid property allotted to the share of Sheikh Jamlu, recorded rayat. After partition, all recorded rayats were separate in mess and cultivation, and all of them had in exclusive possession over their respective share, and accordingly, all recorded rayats, as per their need, transferred their respective share to different persons through registered deed of sale and admitted the partition mentioned therein Bakuda Batwara. Likewise, Sheikh Janglu transferred his share total and area 1.02 acres, including plot number 2198, area 0.09 acres, to registered sale deed of sale, filed deed number 2693 dated 38/1966. That is in my favor. In favor of the defendant, taking full consideration, and since then defendant acquired right, title, interest and possession over the same within the knowledge of all concerned, and got her name mutated and has been paying rent regularly, obtaining rent receipt in her own name. It is further case of defendant that if property in suit is joint property, then all legal heirs and successors of all recorded rayat have to be made party in this suit, as their interest also involved in this suit. It is further case of the defendant that the defendant is in possession over an area 0.09 acres of plot number 2198 since the date of purchase and has constructed his house and khalihan covered by boundary wall on it within the knowledge of all concerned, and in the year 1997 plaintiffs Bhuvan Ansari along with his sons destroyed the boundary wall aforesaid, against which the defendant had filed a complaint, case being complaint case number 90 of 1997, and after trial all accused persons have been found guilty by court and accordingly sentence passed against them. It is further case of the defendant that the defendant has gifted 0.01 acres of land out of 0.09 acres of plot number 2198 for the use of common people, and the land so denoted is used for Idgah. At that time, no one has raised any objection. Even in the recent survey operation Khatiyan prepared and published in the name of defendant, being Khata number 657, plot number 2453, area 0.08, after deducting 1 decimal in favor of Idgah acre, within the knowledge of all concerned, but neither plaintiff nor legal heirs of successor of other recorded rayat has taken any action to correct the entry made in the recent survey Khatiyan, which confirm the possession, right, title and interest of the defendant over this property in suit. It is further case of defendant that the alleged cause of action is false, fabricated and concocted for the purpose of this suit. It is further case of the defendant that cause of action of this suit arose first time in the year 1996 when proceeding under section 144 CRPC initiated between the parties, and lastly on 11th March 1994 when present survey Khatiyan published in the name of defendant, but no action has been taken by the plaintiff, and as such present suit is barred by law of limitation. This is the case of the defendant. And the learned trial court para 20 onwards, running page 7, internal page 7.
उनके पास टाइम नहीं है देखने के लिए, I can't do anything. नहीं देखिए, एक बार अपलोड हो जाने के बाद आपके पास कोई ऑप्शन नहीं है, आपको दिखाने की कोई जरूरत भी नहीं है.
आएंगे.
Paragraph 19. Paragraph 19. I further find that Exhibit A by 1, A by 2, A by 3, A by 4, A by 5, which are registered sale deeds, shown that Sheikh Bhutan, who is the father of one of the plaintiffs, Sheikh Majid, who is also father of another plaintiff, and Sheikh Bhuvan, son of late Masih, and grandfather of one of the plaintiffs, have sold lands from RS Khata number 89 from different plot from time to time, and it has been this 2198 is also within Khata number 89. from different plot from time to time, and it has been mentioned in the said deed that vendor obtained the land by way of partition, Bazaria Bakuda Batwara. Further, find that in the name of Sheikh Jaglu had also sold the said suit land to Bibi Mako, the original defendant. I find that although defendant's witness had admitted before the court that they had not seen the partition paper and do not know which wholesaler got which plot, but in spite of this fact, the different registered sale deed executed by the ancestors of the plaintiffs prove the fact that partition had already been taken place when Sheikh Jaglu had sold the suit land to Bibi Mako. Paragraph 20. Now I find that PW1 in cross-examination admitted that Mako Bibi had instituted a criminal case for allegation of breaking of a boundary wall on him and his son, in which they were fined. He further admitted that in appeal they were acquitted, and he has filed the paper regarding the appeal, but I find that no paper of appeal has been filed by the plaintiff to show that they were acquitted in the appeal against the conviction. PW2 contradicting admitted that the Bibi Mako had not instituted a case upon Bhuvan Ayub, Sayub and Manan regarding the boundary wall. He only admitted that the case was instituted regarding dispute of fetching of water from well. However, Exhibit D is the certified copy of complaint case number 90 of 97, which shows that Mako Bibi had instituted against Bhuvan Ansari, Ayub Ansari, Sayub Ansari and Manan Ansari. It shows that case was instituted by Mako Devi on allegation that Bhuvan Ansari, Ayub Ansari, Sayub Ansari and Manan Ansari have damaged the boundary wall of the land of Mako Devi. I find that they were found guilty. He further admitted that over the land of Khata number 89, plot number 2198, there is Khalian, and over some portion of the land there is house which is constructed by Mako Bibi, but she do not reside in it. I further find PW3 in his cross-examination admitted that he do not know what is written in the examination sheet supported by an affidavit, and he also do not know what is present case for. I further find that PW5 has proved 3 rent receipts which are marked as Exhibit 1, 1 by 1, 1 by 2 respectively, but in cross-examination he admitted that rent receipts are not issued in front of him. I further find that PW5 has proved the original copy of registered sale deed volume entry bearing 2693 dated 3/11/1966, which is marked Exhibit 5 by 1, but in cross-examination he admitted that volume entry is made according to original sale deed, but since he has not seen original sale deed, he cannot say that whether volume entry is correctly recorded or not, and entry in volume is not in front of him.
You see any discussion in connection with any mismatch in the sale deed, etc. Right? It cannot go beyond the pleadings. Had it been there in the pleadings that there is an error in the registered sale deed, with respect to mentioning the plot number, the situation is different. The other side has an opportunity to rebut or to respond. But automatically the court will not venture into this.
Then,
therefore, whenever a suit is filed, the court will see the plot number and other details as recorded and as per the registered. Otherwise, what will be the sanctity of a registered sale deed? Useless. Anybody can say that there is an error in the registered sale deed.
There are a number of plots were sold, transferred
we do
to
not
that.
know what right created when.
It is as per the record.
As per the record,
1.02 acres of land was
you were claiming 2198. The records indicated that it was 2198, and in the registered sale deed that 92 was very faint, right? And therefore the actual case number was the actual plot number was apparent from Exhibit 5 and 5 by 1, which was brought in from the registry office. You can't have
But
it.
as per physical
No,
possession,
that is not
they
enough.
and
No.
they have the plaintiff has never challenged that one.
Need
My
not.
possession has not never been challenged.
You are in possession.
Yes.
You remain in possession.
I am still in possession.
You remain in possession.
But now the first appellate court.
You remain in possession.
Now, the first appellate court, therefore, I find and hold that the plaintiffs are entitled to right title interest as well as possession of 1/4 of the suit land, that is 2 and 1/4 decimal of plot number 2198 area out of 9 decimal. This has been held.
Right
Tab to
title
that-
and interest. There is no order of recovery of possession.
No, that is
नहीं है ना?
that is not
वहाँ पर
there.
आराम से देंगे.
It is not there,
happy?
but automatically then they will chaos will be created.
No, what chaos? Nothing.
Already
No,
one.
You have not taken
Even
You
the
see,
suit was
you
itself
have
they
not
barred by
taken-
limitation.
No, whatever it is. Your entire case was rested on the registered sale. And the registered sale deed, the plot number is different from what you claimed.
The suit has been filed by the plaintiff. I am the defendant.
That's right. Whosoever has filed, this particular deed, when there is a mismatch, was exhibited by you.
Yes.
You were claiming on the basis of this particular deed,
Yes.
correct?
Yes.
Now, this particular deed is indicating that the property which you claimed is not matching with your registered sale deed.
But as per it is not. There is typographical mistake or
From
error
where
in
do
the.
you see, even if there is a typographical mistake, you have to plead that there is a typographical
It is
mistake.
not there, but in the
That
as per the recital of the sale deed,
No.
there is specific boundary.
No,
Yes,
no.
yes. it is.
Even if
I
खलियान तो कितना ही होगा
नहीं ऐसा नहीं खलियान टाड़ा और
खलियान
I am
कितना होगा?
just
How do you identify the property by खलियान
yes,
टाड़?
no, not only that. There is boundary, specific boundary, east, west, south, north. And I am relying on judgment law. May kindly be considered. Para 6 is.
बिना फैक्ट के जजमेंट मत पढ़िए, पहले फैक्ट पढ़िए. Read para 2.
Para 5.
Para 2.
Well, this appeal by special leave is by the legal representatives of the original plaintiffs of West number so and so on the file of Musib Madabad Gobaran at Ajamgarh. This suit was one for mandatory injunction directing the defendants in the suit to demolish further construction put up by them and to fill up a well dug by them in the property claimed to belong to the plaintiff. The plaintiff claimed title and possession over the suit property, which was described in the plate and report demarcated in a sketch. The claim of the plaintiff was that the construction had been put up in plot number 1301/1 BA in village Sarhan Pulla, Pargana Mahal, district Ajamgarh. The defendant resists the suit essentially on a plea that the construction put up by them did not lie in plot number 1301. They of course denied the title and possession claimed by the plaintiff over the proportions in which the construction and the well stood. The suit had a checkered career. There were repeated remands of the suit. What is seen is that ultimately the question boiled down to that of identification of the property with reference to the disputed portion. Ultimately, in the present round, the trial court decreed the suit, holding that the plaintiff was the owner of the suit land which had been identified on the spot and was hence entitled to the relief's claim. An appeal filed by the defendants was dismissed, holding that the disputed constructions lay in the suit property described in the plaint, that the plaintiff had title to it, and that the trial court was hence right in decreeing the suit. Thus, the appeal filed by the defendants was dismissed. The defendant filed a second appeal before the High Court of Allahabad. The High Court upheld the findings rendered by the courts below that the plaintiff was exclusive owner of plot number 31301/1BA. The High Court found that there was no illegality in approach made by the courts below in arriving at the finding, and the finding was based on the evidence on record. But in spite of this finding, the High Court reversed the judgment and decree of the first appellate court and dismissed the suit on a finding that there was no proper identification of the suit property by the plaintiff, either in the plain or at the spot, and since the boundaries cannot be ascertained without surveying the adjoining plots, no decree could be granted to the plaintiffs.
The identification in this particular case
Yes, identification.
was duly done by a commissioner,
Yes.
local inspection,
Yes.
and the suit property was duly identified.
Yes.
Right? It is not a case where any sale deed, etc. is.
No. That is not there. But para 6 may kindly be seen.
I've seen.
Directly I am coming to the para 6. The High Court has also upheld the title claimed by the plaintiff over the suit plot number 1301/1BA. Once we accept the identification made by the commissioner as was done by the first appellate court, it is clear that the plaintiff has the right to have the disputed construction removed and the well filled up. That a property can be identified either by boundary or by any other specific description is well established. Here, the attempt had been to identify the suit property with reference to the boundaries
See,
and the commissioner.
In a case where you are claiming title by virtue of a registered deed of sale,
There is also
Right.
a boundary is there.
no, boundary must be there. There is a
Boundary is there.
registered deed of sale, and you do not take a plea that the plot number is wrongly mentioned therein. Then how the court can enter into this kind of a dispute? You should have been fair enough to say that the plot number is wrongly mentioned. You did not say so.
It is not. But I am in position.
You
All
will
along,
remain in
even the description of land, as per the description of land, the land is Khalianta. And whereas the 2192 is Kabrastanta. 2192 is Kabrastanta. It is there. Even in the judgment it has come. उसम महतो का प्लॉट है, खतियान से बिलोंग करता है. ट्रायल कोर्ट का पैरा 22 Para 22 में specific करके आया है. I further find that on the other hand, the defendant's witness DW1 and DW5 stated before court that after purchase of the suit land from Joglu, BB Mako came into possession of the suit land, and after getting land, she got the land muted in her name and started paying rent to the government. DW6 stated that she is submitting the attested copy of old RS map of village Sinha and new map relating to the same village. The original hull survey map is marked Exhibit B. As per the defendant's case, the new survey khata plot number 2453 R 0.08 acres is registered in the name of BB Mako. It is also case of the defendant that from purchase, a purchase area 0.09 acres from RS plot number 2198, 0.01 acres of land was gifted to Idga for use of common people by BB Mako. Find Exhibit G and G by 1, which is a certified copy of the present survey Khutian of Khata number 657 and 656 shows that the record dated in the name of BB Mako. In this way, it has approved by the defendant that the new survey Khutian of Khata number 657 and 656 is recorded in the name of BB Mako. And they have never challenged this.
Who produced the registered deed?
Both from both sides.
No.
Means I have also produced. The defendant has produced.
Who produced the original deed?
Registered original deed I have produced.
You have produced the original deed, where it was mentioned 2192. And in the registered deed it was found 219. 2198. Isn't it?
Original registered sale deed bearing number 2693 dated 3856 Exhibit A dependents. तो पैरा 24 का 4 में इसका रिफ्लेक्शन है ट्रायल now I find that it is a case of plaintiff that the RS खाता number 89 plot number 2192 but under misconception deed executed
ये misconception word कोर्ट कहाँ से लेके आए? Out of the pleading.
नहीं ट्रायल कोर्ट का ये
No,
फाइंडिंग्स
where is the foundation pleading to this effect?
2198 on the other hand it is a case of the dependent.
Misconception, who will say misconception? The court would say or the parties would say? देखिए हो गया?
परफेक्ट माइंड बट माय लॉर्ड ओनली थिंग इज दैट मेरा चैम्बर जो इस हाईकोर्ट के बिल्डिंग का सबसे अंत में वहां से यहाँ आने में जो देरी है इसीलिए हमको देरी हुआ अदरवाइज मैं जूनियर
आपने देख लिया ना, आपका राइट प्रोटेक्टेड है।
मेरा राइट प्रोटेक्टेड आई एम ग्रेटफुल।
अदर साइड भी देखना चाहे तो उनको खबर कर
हाँ, वो देख रहे
दीजिए,
हैं।
आप देख लीजिए उसको।
A certified copy of the same registered sale deed, photocopy of the same volume entry or sale deed which has been executed by say example in favor of the BB Marco. I find that exhibit 5 and 5.1 the plot number is mentioned at 2192. On the other hand, dependent had got exhibited the original sale deed which is exhibit A executed in favor of BB Marco. I find from the result of exhibit A the plot number which has been purchased by BB Marco is mentioned at 2190. Fine, I find that it is the case of the plaintiff that since the plaintiff, since plot number 219 it is not being purchased by BB Marco, so she do not have any right, title, interest over it. I find that the dispute exists between the parties is whether BB Marco has purchased plot number 2192 or 2198. I find exhibit 5 and 5.1 and exhibit A, the name of the land is mentioned as Khalianta. I further find that exhibit 2 is the certified copy of RS Khata number 89. RS Khata number 89, exhibit 2. And same exhibit E, which shows that RS Khata number 89, plot number 2198, the name of the land is Khalianta, while the name of plot number 2192 is Gaurastanta. So, under such circumstances, when there is dispute regarding plot number, whether it is 2192 or 2198 or 2192, I am deciding the dispute according to the name of land, as there is a very minute difference in writing between the Hindi numeric digit 9 and 2. I find that in all the registered sale deed which has been exhibited on behalf of both the sides shows the name of land as Khalianta, all the sale deed. And from perusal of exhibit E, which certified copy of Khata number 89 shows that against plot number 2198, the name of the land is Khalianta. Under such facts and circumstances, I find and hold that the RS Khata number 2198 under RS Khata number 89 is being purchased by BB Marco. Thus, on the basis of discussion made above, issue number 78. But if the original plaintiff is claiming 1/4 share, then obviously she ought to have been filed a suit for partition and not for declaration of right, title, interest. And it is hopelessly barred by limitation. फर्स्ट एपिलेट फुट का सी पॉइंट पर प्लॉट नंबर का फाइंडिंग्स जो है रनिंग इंटरनल पेज 16 से 16 का मिडिल तो the perusal of exhibit 6.
It was never your case that there was an error in this one.
Yes.
It was never your case. Or the learned counsel appearing on behalf of the applicant. This appeal has been filed against एग्रीड पोर्शन लिखे ही नहीं है. Against the judgment passed by the District Judge Roman 4, Lohardaga, dated 20/12/2019, in the imperative decree signed on 4/1/2020, passed in title opinion number 30 of 2012, reversing the judgment dated 29/8/2012, in the imperative decree dated 7/9/2012, passed by the Civil Judge Junior Division number 4, Municipal Lohardaga, entitled suit number 9 of 2003. The suit was dismissed and the appeal was allowed. Consequently, the defendants are the appellants before this court. The learned counsel for the appellant has submitted that essentially the suit was in connection with plot number 2198 of Khata number 89, area 9 district of Khata number 89, Khata number 89. And the defendant claimed that they had purchased the suit property by registered sale deed bearing number they had purchased 1.02 acres of land by registered sale deed bearing number 2693 of 1966. They submitted that the learned trial court dismissed the suit by observing that the identity of the suit property was by observing that the issue was whether the plot number in the registered deed was 2198 or 2192, and observed that there was a very minute difference in the registered sale deed exhibited by the defendants and proceeded with respect to the identity of the suit property as Khalian Park. He submits that thereafter the suit was dismissed. However, the learned first appellate court has reversed the judgment passed by the learned trial court by referring to the Exhibit 5 and 5 by 1, which was a document produced from the office of District Sub-Registrar Lohardaga, in which, with respect to the registered sale deed, plot number 2192 was mentioned. The learned counsel for the appellant has submitted that once the identity of the property as Khalian Park was established, it made no difference if there was an error in the registered sale deed by recording the plot number as 2192 while recording the plot number. It submits that this aspect of the matter was properly considered by the learned trial court, but the learned first appellate court has wrongly reversed the finding, and accordingly a substantial question of law being framed. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in 2006, Supreme SC 584, and has referred to paragraph 6 and has submitted that it has been held that the property can be identified either by boundary or by any other specific description and either by boundary or by any other specific description is well established. However, during the course of argument and upon a query made by this court, the learned counsel for the applicant has fairly submitted that it was never the case of the defendants that the plot number was wrongly mentioned in the same or there was any error in connection with the same. After hearing the learned counsel for the appellant, this court finds that the suit was filed by the plaintiff seeking a declaration of right title interest over the suit land mentioned in Schedule A of the plate in connection with Village Senha, P.S. Senha, District Lonadarga under RS Khata number 89, block number 2198, area 0.2 and a half